Catfishing led to the deaths of the 3 most important people in my life.
Allegedly stated you'd already killed one person and wanted to kill another.
I just said, he murdered my daughter. If he can't take being confronted by a woman, well, I'm sorry, but he's not much of a man if he can't handle that.
In April 2007, Michelle McNeel, a mother of 8 from Pleasant Grove, Utah, was found unresponsive in the bathtub of her home while recovering from a cosmetic procedure. Her husband, Dr. Martin McNeel, reported finding her there. At the time, her death was considered accidental and no criminal charges were filed. In the years that followed, several of Michelle's family began questioning their father's behavior and the circumstances surrounding their mother's death.
It was a big bloody mess. It was just all of these things are just thrown in the garage.
Their concerns led authorities to reopen the case. In 2012, prosecutors charged Martin McNeel with first-degree murder and obstruction of justice, alleging that Michelle's death was not an accident.
Do you recognize this man sitting right here?
Yes.
Who is he?
It's my father. Growing up, my father was my best friend.
During the trial in 2013, McNeel's daughters, including Rachel McNeel, testified about events before and after their mother's death.
It was my father's voice. He said, "Rachel, quick, get to the hospital. It's your mother. Quick." I said, what's happening? Is everything okay?" And he just said, "Rachel, come home."
Rachel described receiving an urgent call from her father on the day Michelle died and said his behavior afterward felt unusual.
He specifically said to me that he was concerned that there'd be a police investigation, that he didn't want anyone to think that he murdered my mother. I said, why? Why would anybody think that?
She also described his behavior during the funeral.
He was making jokes about being single and just laughing, and it made me sick. I left.
Prosecutors also presented evidence that McNeel began a relationship with Gypsy Willis, who moved into the family home shortly after Michelle's death.
It just was obvious that she's just goo eyes at my dad and wasn't doing anything a nanny would do.
The defense argued that McNeel was grieving and denied wrongdoing. On November 9, 2013, a jury found Martin McNeel guilty of murder and obstruction of justice. In September 2014, he was sentenced to 15 years to life in prison, along with additional time for related convictions. While serving his sentence, McNeel remained incarcerated at Utah State Prison. On April 9, 2017, prison officials found him in his cell. Authorities later ruled that he took his own life. In October 2025, emergency crews responded to a fire at a home in Buffalo, New York. Inside the residence, authorities later found Kathleen Carey and her son, Noah, both Kadane Haley, the boy's father and Carey's partner, was also at the scene and was taken to a hospital before being arrested. Investigators later charged Haley in connection with their deaths, and he was held without bail while awaiting trial. Haley was arraigned later in October and faced serious charges that carried the possibility of life in prison.
If convicted of that offense, he faces a maximum possible sentence of life in jail.
Over the following weeks, he remained in custody at the Erie County Correctional Facility in Alden as the case moved through early court proceedings. On the evening of December 10, 2025, correctional staff found 30-year-old Kadane Haley unresponsive inside the jail. He was pronounced later that night. Authorities believe he took his own life, though the incident remains under investigation. An autopsy was scheduled to determine the official cause of death.
And deaths have ticked down a little bit.
And although we've had one death, you all know all too well that one death is one too many.
Following Haley's death, the Erie County District Attorney's Office announced plans to dismiss the indictment as the case could no longer proceed. Haley's defense attorney released a statement expressing sadness and suggested that mental health struggles may have contributed to the situation. Officials also reminded the public that mental health support resources are available for anyone in need. In January 2006, Nicole Pietz, a mother from the Seattle area, was reported missing after she failed to show up for plans with friends. Her husband, David Pietz, told police that she had been asleep when he left for work and was gone when he returned home the next morning. At first, her disappearance was treated as a missing person case. About a week later, Nicole's body was discovered in a wooded area near SeaTac. Investigators confirmed she had been and the case shifted into a homicide investigation. From early on, detectives considered David Pietz a person of interest, but they said there was not enough evidence at the time to make an arrest. For several years, the case remained open while Nicole's family, especially her mother, continued pushing for answers.
I just said, he murdered my daughter. I have cried my brains out every day for 7 years. If he can't take being confronted by a 72-year-old woman, well, I'm sorry, but he's not much of a man if he can't handle that.
Investigators revisited evidence as technology improved, including advances in cell phone tracking and DNA testing. In 2012, more than 6 years after Nicole's police arrested David Pietz and charged him with second-degree murder. Nicole's mother testified about his unusual behavior during her funeral.
Try and focus on what we can do to be finding her so that we, so you don't let your mind go to the bad places.
Pietz later pleaded not guilty, and the case went to trial in 2013. Prosecutors presented a case built on circumstantial evidence, while the defense argued there were no eyewitnesses and challenged the conclusions.
It's not based on any direct evidence, and it's not going to show that David Pietz took Nicole's life.
After hearing weeks of testimony, a jury found David Pietz guilty in October 2013. The following month, he was sentenced to about 18 years in prison. In late November 2022, a disturbing case unfolded in Riverside, California, after police responded to a house fire at a home on Price Court. Inside, authorities later found 3 members of the Winnick family: Mark, his wife Sherry, and their adult daughter Brooke. Investigators quickly began looking into how the tragedy occurred and identified the case as a targeted attack.
If something like this horrific tragedy can happen here, in our neighborhood, in our community, it can happen anywhere.
Detectives soon connected the incident to Austin Lee Edwards, a 28-year-old former Virginia state trooper and newly hired sheriff's deputy. Authorities said Edwards had been communicating online with a girl, pretending to be someone else. Police believe he traveled from Virginia to California after forming that online connection. A neighbor noticed Edwards leaving the home with the girl and saw smoke coming from the house, then immediately called for help. Officials later said that quick call helped save the girl's life.
Making that call from that neighbor saved my niece's life, and that neighbor is a hero in our eyes.
Later that same day, law enforcement located Edwards while he was driving with the girl in San Bernardino County.
We don't know yet if she was threatened, coerced. We're not describing it as a kidnapping at this point, but we also don't have any reason to believe that she was complicit in any of these or the fire as well.
The surviving family members spoke publicly, urging parents to stay involved in their sons' and daughters' online activity and raising awareness about the dangers of online deception.
This horrific event started with an inappropriate online romance between a predator and a child. Parents, please, please know your child's online activity. Ask questions about what they are doing and whom they are talking to. Catfishing led to the deaths of the 3 most important people in my life. My dad, my mom, and my sister. They are forever in my heart, and I miss them deeply.
On November 25th, 2022, during an attempt to stop the vehicle, Edwards died from a self-inflicted wound, according to the coroner. The girl was safely recovered and placed in protective custody, where she began receiving trauma counseling. In July 2013, a tragic case unfolded in Shagdacoke, Rensselaer County, New York. On July 4th, police responded to a home where Cynthia and Michael Matala were found Authorities later charged their son, 22-year-old Anthony Repp, in connection with their deaths. After leaving the scene, Repp fled the area and was arrested the following day in Deerfield, Massachusetts, before being returned to New York to face charges. The case moved through the courts over the next year. In December 2014, Repp pleaded guilty to 2 counts of second-degree murder as part of a plea agreement. During proceedings, his attorneys acknowledged his history of mental health issues, but evaluations found him competent to stand trial.
Well, listen, I don't think there's any question that this defendant's conduct exhibits the most abhorrent and disgusting actions that anybody can really fathom. Bludgeoning your mother to death with a rock and your stepfather in the same fashion.
It is over. It's a tragedy, no matter which way you look, and it very deeply has affected both sides of a good family.
On January 29, 2015, a judge sentenced Repp to 40 years to life in prison, a decision that spared the victim's family from a lengthy trial. Relatives addressed the court through victim impact statements, describing their grief and the lasting impact of the loss, bringing the case to a close. In early December 2025, family members in Houston, Texas became worried when 41-year-old Crystal Rose Angel Ramirez stopped responding to calls and messages. They said it was unusual for her to go silent, especially on social media, and reported their concerns to authorities. According to court records, Ramirez was last seen at her home in the Independence Heights area. Investigators later identified her boyfriend, 48-year-old Jesus Varela, as the primary suspect in her disappearance.
They said he was asleep, and he told her while she was asleep, and then started bagging her up.
On December 6th, police arrested Varela after a family member reported that he had been pressured to help remove items from the home and hide evidence. That information led investigators to expand their search.
Allegedly stated you'd already killed one person and wanted to kill another.
On Wednesday, December 10, 2025, Houston police located Ramirez's body inside a barrel, left in a wooded area near the Greenspoint section of North Houston, close to Interstate 45. Her family later confirmed her identity. Authorities also revealed that police had responded to a domestic dispute at the couple's home in November, weeks before her disappearance. Ramirez's family has since spoken publicly, describing her as a caring and generous person.
And now I feel anger, I feel depressed, I feel, like it doesn't happen, it ain't real, and I just cry every day. And I cry in the morning, I cry at night.
They say they are seeking justice and hope her case encourages others in unsafe relationships to seek help before it is too late.
She didn't deserve this. She helped the whole world. She helped strangers.
I just want justice for my daughter.
Varela was charged with felony murder, along with tampering with evidence, assault involving a family member, and unlawful restraint. He remains in the Harris County Jail, held on bond, and an ICE immigration hold, as the case continues through the court system. The case began on Mother's Day, May 10, 2020, when Susie Morphew disappeared after planning a bike ride near her home in Chaffee County, Colorado. When she did not return, family members reported her missing, prompting a large search effort by law enforcement and volunteers. For several years, investigators continued working the case without filing charges. In September 2023, the investigation took a major turn when Suzanne Morphew's remains were discovered in Saguache County, providing new direction for authorities.
We believe that she's not alive.
We do have information that led us to this point today and how we think a certain scenario had occurred.
On June 18, 2025, a Colorado grand jury indicted Suzanne's husband, Barry Morphew, charging him with first-degree murder in connection with her. The same husband gave this interview after her disappearance.
I will do whatever it takes to get you back. Honey, I love you.
Investigators said the indictment was based on newly developed evidence, including digital and vehicle data gathered over time. 2 days later, on June 20th, 2025, Barry Morphew was arrested in Arizona. He waived extradition and was returned to Colorado to face the charges.
Thought that he did it from the beginning. There's still a lot of questions of what happened to her. Where is she? Why? Why would you do this? to someone that you've been with for so many years.
In September 2025, Morphew appeared in court in Alamosa, where a judge set his bond at $3 million. His legal team asked for a lower amount, but the request was denied. Later that month, as of November 2025, a judge also ordered limits on pretrial publicity to ensure a fair legal process. In October 2011, police in Keller, Texas, responded to a 911 call from Michelle Williams, who reported that her husband, Gregory Williams, had been found unresponsive inside their home. At first, Michelle told investigators that an intruder was responsible. As the investigation continued, officers found no signs of forced entry, and her account later changed. She then claimed her husband had taken his own life and that she altered the scene out of panic. In the weeks that followed, investigators reviewed evidence and financial records, noting that Michelle Williams stood to benefit from multiple life insurance policies. The medical examiner later ruled Gregory Williams' death a homicide. In January 2012, Michelle Williams was arrested and charged. The case moved slowly through the courts for several years, with hearings, delays, and legal motions. In 2013, Williams agreed to a plea deal on lesser charges, with prosecutors recommending an 18-year sentence. However, sentencing was postponed after she falsely claimed to be pregnant. During that delay, Williams gave media interviews in which she publicly maintained her innocence. Because her statements conflicted with the plea agreement, the judge threw out the deal and stepped away from the case, along with her defense attorney. The case was reset for trial, and in September 2014, a jury was selected in Tarrant County. After hearing testimony and reviewing evidence, jurors found Michelle Williams guilty. She was later sentenced to 60 years in prison, bringing the long-running case to a close. On Sunday morning, September 15, 2024, police in Hamburg, New York, were called to a home on McKinley Parkway just after 8 a.m. to conduct a welfare check. When officers arrived, they encountered 33-year-old James McCulla, who was inside the home and initially refused to cooperate.
He was at first belligerent to them, did not want them to come inside the house. We have an officer that has previous experience with him, had gone to high school with him, was able to build rapport with him to the point where Mr. Jenny allowed them to come inside the house to investigate the welfare check.
After an officer familiar with him was able to calm the situation, police were allowed inside. There, officers discovered his mother.
Through the patrol response, through the detective response in the investigation, evidence was obtained that we feel shows that Mr. Jenny his mother.
The home was secured, and detectives began an investigation that same day. Based on evidence collected at the scene, police determined her death was a homicide. Later that Sunday night, September 15th, James McCulla was arrested.
Rita was obviously in a situation that I almost analogized to a spousal abuse situation. There was an incident where she actually had to escape from her house and her son and ended up in my house. That was probably 8 years ago.
Investigators also confirmed the residents had a history of domestic incidents dating back to 2016, though there was no active order of protection in place at the time of his mother.
James Jenny had been arrested on 2 previous occasions at the house. There was no order of protection in place at this time. There had been previously, but we have been to the house several times.
On Monday afternoon, September 16, 2024, McCulla was arraigned in Town of Hamburg Court and pleaded not guilty to a charge of second-degree murder. The court appearance was briefly disrupted when he spoke out during the hearing, but proceedings continued. As of now, Hamburg police detectives continue to process evidence from the home while the case moves forward through the court system. In Grand Rapids, Michigan, a boy was injured last year after accidentally gaining access to a firearm inside his home. He was taken for medical treatment and survived. Police later investigated how the boy was able to reach the weapon and determined it had not been stored safely. At the time, Michigan's safe storage law, passed earlier that year, required weapon owners to keep unattended firearms unloaded and locked when it is reasonably known that a minor may be present in the home. Following the investigation, the boy's father, Nakobi Thomas, was charged with a safe storage violation and later pleaded guilty in October. The case returned to court in Kent County for sentencing, where a judge ordered 2 years of probation along with a 4-month jail sentence that was suspended, meaning it would only be enforced if probation terms are violated. In February 2025, police in Holland City, Michigan, received a call from an apartment at the Bay Point complex. When officers arrived early that morning, they encountered 39-year-old Katie Lee holding a weapon. She did not immediately follow their commands, and officers were eventually forced to disarm her for everyone's safety. Inside the apartment, they found her son, Austin Dean Pietz, who was unresponsive. Detectives began piecing together what happened. Through interviews and later court testimony, they learned that earlier that day, Katie had given Austin a sedative that left him unable to fully control his body. According to prosecutors, once he became unconscious, she continued to act in ways that caused him extreme physical and emotional harm. The medical examiner later confirmed that these actions led to his death. Katie told officers she was overwhelmed and had called the police afterward. However, when authorities arrived, she resisted them, which added an obstruction charge to the case. As the investigation moved forward, Katie underwent psychological evaluations. Her defense team considered an insanity defense, but eventually she decided not to pursue it. Prosecutors initially charged her with open murder, the most serious charge in Michigan, while the court reviewed the facts. In October 2025, just before the case was set for trial, Katie Lee appeared before a judge and chose to plead guilty.
This is People of the State of Michigan versus Katie Austin Lee, case number 25-47529-FC. Today is the date and time scheduled for a plea. Your Honor, the plea agreement is as follows. If the defendant enters a plea to amended count 1, which is second-degree murder, count 2, which is assaulting, resisting, or obstructing a police officer, and added count 3 of torture. There's also a sentence agreement, Your Honor, that the defendant, if the plea successfully goes through, would serve a minimum of 60 years in the Michigan Department of Corrections.
That is a correct statement, Your Honor.
Thank you. Ma'am, would you please stand for the date administering the oath and raise your right hand, please? Do you solemnly swear or affirm that the testimony you are about to give will be the truth?
Yes.
And you may be seated right there, ma'am.
May I approach, Your Honor?
Absolutely. And if you can move that microphone close to ma'am, do you understand why you are here this afternoon?
I do.
Have you had an adequate opportunity to talk over this plea procedure with your attorneys before we begin?
I have.
And do you wish to proceed?
Yes.
The named offense in count 1 to which you're going to plead guilty is called second-degree murder. This is a felony which carries with it a maximum penalty of up to life imprisonment. Do you understand the name of that offense and the maximum possible penalty?
Yes.
As pertains to count 2, the named offense to which you're going to plead guilty, this is called resisting and obstructing a police officer. Once again, this is a felony which carries with it a maximum penalty of up to 2 years of incarceration. Do you understand the name of that offense and the maximum possible penalty?
Yes.
And finally, count 3, the named offense to which you're going to plead guilty is called torture. Once again, this is a felony which carries with it a maximum penalty of up to life imprisonment. Do you understand the name of that offense and the maximum possible penalty?
Yes.
I also want you to understand that if you are not a United States citizen, these convictions could result in your deportation from the United States. Do you understand that?
Yes.
Your attorney just a moment ago handed me an advice of rights form. Is that your signature on the bottom right?
Yes.
Can you see that?
Yes.
Did you read all these rights with your attorney?
Yes.
Do you understand all of these rights?
Yes.
Do you have any questions about any of these rights?
No.
I want you to understand that if I accept your plea of guilty, you're giving up all of the trial rights that are listed on this document. You understand that?
Yes.
And I'm just going to go over these again individually just to make sure that you fully understand what you're giving up. I want you to understand that if your plea of guilty is accepted, you will not have a trial of any kind, and you'll be giving up the following rights that you would have had at trial, including the right to be tried by a jury, the right to be presumed innocent until proven guilty, the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty. You'd have the right to have the witnesses against you appear at the trial. You would have the right to question those witnesses against you. You'd have the right to have the court order any witnesses you have for the defense to appear at the trial. You would have the right to remain silent during the trial and not have that silence used against you, and you would have the right to testify at the trial if you wanted to testify. Ma'am, do you understand that if I accept your plea of guilty that you're giving up all of the trial rights I just listed for you?
Yes.
The plea agreement, as I understand it, is as follows. It's really in 2 parts. Number 1 is the charging instrument. Number 2 is the sanction. In exchange for dismissing the open murder, which is a first-degree murder charge, you'd be pleading guilty, which carries with it a mandatory imprisonment of life imprisonment without the possibility of parole. That charge will be removed. So you'd be pleading guilty to counts second-degree murder, resisting and obstructing, and torture, as I mentioned. And in addition, there's a sentencing agreement that you and your attorneys have apparently entered into at which case the court would sentence you to a minimum period of incarceration in prison for 60 years. The maximum would be set by the court, and frankly, it would be 90 years. So the plea agreement is basically, it would be 60 years on the minimum, up to 90 years on the maximum. For counts 1 and 3, they would be concurrent with each other. Count 2 is just a 2-year felony. Do you understand what I just said? Yes. Do you understand that there's a minimum prison sentence that's going to be imposed and a maximum prison sentence that's going to be imposed? Do you understand that?
Yeah.
Is that your understanding of the complete plea agreement?
Yes.
Besides the plea agreement, have any other promises been made to you as an inducement that has caused you to enter these pleas of guilty?
No.
Have you been threatened in any way so to cause you to enter these pleas of guilty?
No.
I want you to understand that if I accept your pleas of guilty, you are giving up your right to claim that these pleas were a result of any promises or threats that were not disclosed at this hearing, or that the decision to plead guilty was not given of your own free will. Do you understand that?
I do.
Are you pleading guilty freely and voluntarily?
Yes.
Are you pleading guilty because you are in fact guilty?
Yes.
Regarding count 1, second-degree murder, how do you plead?
Guilty.
Count 2, resisting and obstructing a police officer, how do you plead?
Guilty.
And finally, count 3, how do you plead to charge of torture?
Guilty.
Is it true that on or about February 21 of 2025, you were in Holland City, Ottawa County, Michigan?
Yes.
Okay. And you are the mother of Austin, correct?
I am.
And on that date, he was 18 years old, a minor?
Yes.
And did you administer a drug or a sedative to him?
I did.
As a result of administering that drug or sedative to him, was he unable to have control over his body?
He was.
I'm sorry?
Yes.
Okay. So you administered a drug and thereby he no longer had physical control of his body. Is that true?
True.
And then you then exercised physical control over his body. Is that fair to say?
Yes.
And while you had him under your control, did you intentionally inflict severe mental pain or anguish on him?
Yes.
And did you administer a mind-altering substance to him?
Yes.
And that was done deliberately?
Yes.
And by the administering of that mind-altering drug, did that disrupt his sense of personality, his senses or personality?
Yes.
You then, is it true that while he was under your control and unconscious that you then had a knife? Is that true?
Yes.
And did you his arm on at least 2 occasions?
Yes.
And then did you also use that knife to his throat?
Yes.
As a result of using his throat, did that result in his death?
Yes.
And ultimately, you actually called the police at some point in time. Is that true?
Yes.
And the police arrived. Is that true?
Yes.
And they encountered you. You still had possession of the knife. True?
Yes.
Did they order you to drop the knife?
Yeah.
Did you immediately comply with their request to drop the knife?
No.
In fact, they ultimately had to use a taser, some force on you. Is that true?
Yeah.
Okay. Now, as it pertains to the assault on your son, did you have any legal reason or justification in administering him those?
No.
Did you have any lawful reason in using physical force against him?
No.
Mr. Bartholomew, before I proceed further, I note that there was a competency examination that was done of your client earlier. Is that true?
That is correct.
And she was deemed competent to proceed with these matters?
She admitted to second-degree murder, torture, and resisting police officers. Prosecutors agreed to drop the original open murder charge, but the remaining charges still carried severe penalties. As part of the plea agreement, Katie accepted a prison term of 60 to 90 years, meaning she will spend the rest of her life in the Michigan Department of Corrections. She confirmed to the court that her plea was voluntary and that she understood the consequences. Her sentencing was scheduled for January 19, 2026. In In early February 2025, deputies in Backcliff, Texas were asked to check on a woman who had not been heard from. When they arrived at the home, they discovered that Tammy King, a local resident, had been killed. Investigators quickly determined it was not a natural death and began treating the scene as a homicide. As the investigation unfolded, attention turned to two people who had recently been staying at the home, Tara King and her boyfriend, Uriah Urick. Witnesses told police there had been ongoing tension in the house in the days leading up to the incident. Shortly after the discovery, both Tara and Uriah were reported missing, and authorities issued alerts for their whereabouts. Within days, law enforcement confirmed that the pair had left the area. Surveillance footage, phone records, and social media activity helped investigators track their movements. On February 9th, 2025, Tara King and Uriah Urick were located and arrested in Laredo, Texas, near the southern border. Both were charged with capital murder and taken to the Galveston County Jail, where they were held without bond. During the investigation, police also identified a third person connected to the escape, Travis Hodge. Hodge had prior convictions and was known to be involved with drugs. Authorities learned that Urick contacted Hodge after seeing online posts stating that he and Tara were wanted by police. Urick asked Hodge for help in leaving the area. Hodge later admitted that Urick offered him $1,000 to drive them out of town. He testified that Urick initially claimed the incident was self-defense, but later said that explanation would not hold up based on how the scene looked. Despite knowing Urick was wanted, Hodge agreed to help and drove the couple away from Backcliff. During the trip, Urick appeared nervous and frequently looked around, fearing they were being followed. Hodge was eventually arrested and charged with hindering apprehension, along with drug-related offenses. In exchange for a plea deal, he agreed to testify truthfully in court about his role in helping the couple flee.
I want to ask you, do you know anyone by the name of Uriah Urick?
I do now know that Uriah Urick is also somebody that I knew by Percy.
So you know that the person you know of as Percy has the actual name Uriah Urick, is that correct?
Yes, ma'am.
Do you see the person you know as Percy in the courtroom?
Yes, ma'am.
Can you please tell me where he's seated and an item of clothing?
In the blue, or black or blue shirt over there.
Your Honor, may the record reflect this witness has identified the defendant.
The record will so reflect. Can I see the attorneys very briefly, please?
Mr. Hodge, how did you meet Percy?
I met Percy at a local Backcliff. He had just gotten burned on some drugs and was looking for more. And I just happened to have about 3.5 grams on me. And so I gave him a gram just because.
And at that point, did you sell the gram to Percy or did you just give it to him?
At that point, he tried to pay me for it and I told him no. He could just have it.
And do you recall when that was?
I want to say, I think in December.
Of 2024?
Of 2024, yes.
And after that initial meeting with Percy, how often did you talk to or see him?
For a while I didn't until his friend Jaden gave him my number, and then he contacted me one day, and I was a little pissed about it, but Jaden gave me my number, and he's like, hey, can I get some stuff? And I was like, I'm at work right now, I'm not getting off for a while. He's like, well, I can come by your work. I really didn't want to do that, but he eventually talked me into letting him come by with my job, and he ended up picking up the gram from me at my work.
And at that point, did you give it to him or sell it to him?
At that time, I did sell it to him.
And about how many times would you say that you had sold methamphetamine to Percy?
Maybe 5 or 6 times.
Now, I want to bring your attention to early February of 2025. Do you recall that time period?
Yes, ma'am.
During that first week of February, how long had it been since you'd talked to Percy?
Before February 7th, he contacted me a few days before that and had asked if he could come stay at my house with a couple of days, and I had told him no. And then on February 7th, I had contacted him because I seen a post about him and Tara King wanted for credit card or debit card abuse. And so I was trying to find out what was going on, and that's when we started kind of talking, and he asked for a ride.
And at that point, did you know Tara King?
I did not. I had never met her in my life.
So when you started talking to Percy, how did you communicate with him?
Through text message.
And
Is that because y'all already had each other's numbers?
Yes.
So when you reached out to Percy, tell me about that conversation.
I asked him what was going on. He said he really couldn't talk about it. I was like, what do you mean? He's like, it was self-defense. And I was like, what was self-defense? And then he just never answered then. And then he asked for a ride to Illinois, and I told him I couldn't take him to Illinois. And so after that, we kind of talked a little bit, and I was like, well, I can take you to like Mexico.
Why was it you suggested Mexico versus Illinois?
Because he was trying to go to Canada to the border. And I was like, well, you know there's a border that's closer.
So proximity?
Yeah.
So when you said you could take him to Mexico, what was the next thing that occurred?
He's like, I'll pay you $1,000 to take him down there.
Did anything about, at this point, did anything about what was happening strike you as odd or concerning, or what are you thinking?
Yes, it did strike me odd, but at the same time, I was like, well, I was trying to figure out what was going on. And at the same time, I was like, at the time, I didn't really care.
Once you had the conversation about he'd give you $1,000 for the ride, what, if anything, do you do next?
I leave work at 5 o'clock that day, and I go and drop my roommate off that I was staying with off at the house, and I go and pick him up at an apartment in League City.
And did he give you an address to go to, or how did you know where to go?
He gave me an address to go to, and I went and picked him up. And at first I passed the apartment, and he's like, no, turn around. And I turned around and parked right in front of the apartment. Uriah and Tara both came out. They had at the time I did not know it was a gun. They had something wrapped up in a blanket, along with 3 or 4 different bags and a dog.
What did the dog look like?
A little black and brown tan, I believe.
And so, at this point, had y'all still only communicated by text message, or did y'all communicate any other way?
We actually did. I did suggest that we move over to like an encrypted app, because I mean, we were doing something kind of illegal.
Was it kind of illegal or just illegal?
We were doing something illegal. I was giving him a ride, even though I knew that he was wanted by the Galveston County Police, or Galveston County Sheriff's Office.
And so I'm going to kind of put a pin right there, because that's something that we need to talk about. We see that you currently, as we said, are residing in the Galveston County Jail, correct?
Yes, ma'am.
Why?
I am currently facing charges of possession or manufacturing and delivery of a controlled substance into Group 1, namely methamphetamine, as well as I'm facing a gun charge and also a hindering apprehension charge.
And have you entered into an agreement with the state of Texas?
I have.
And do you recall what that agreement is?
I do. It is 10 years in the Texas Department of Criminal Justice.
Is it on all 3 charges, or 2 charges, or 1?
It is on 2 charges. It is for the manufacturing and delivery of methamphetamine and the hindering apprehension.
And is that also in exchange dismissal on the unlawful possession of firearm by a felon?
Correct.
And as part of the agreement that you have entered in with the state, what are you required to do?
To testify.
Do you just have to testify, or do you
testify and tell the truth?
Tell the truth. Thank you. And is your agreement to testify in any trials to do with this case?
Yes.
Now, like you just said, at the time that you were going to give them a ride, you knew that they were charged with a felony, correct?
With credit card or debit card use, correct.
Okay. Now, once you arrive at this apartment in Lake City, tell me what happens.
When I picked him up, like I said, they had a blanket, and at the time I did not know what was in the blanket until after the fact. But Uriah gets in on the passenger side, he throws in the blanket, and he has a couple of shoulder bags, and he throws them in the car. Tara comes to the driver's side, throws in a couple of bags along with the backpack, and then she tries to get the dog in. The dog gets loose, and she's trying to get in the car, or get the dog in the car, and Uriah tells her, just leave the dog and get in.
Now, when you're saying that Tara was trying to get in the driver's side, where are you?
I'm in the driver's side. and she was in the back seat and I was in the front seat.
And then when you said Percy or Uriah was trying to get in the passenger side, was that the front or the back?
In the back.
Okay. So Uriah says, leave the dog.
Yes, ma'am.
What occurs next?
We leave the apartment. I go down to Main Street and I turn right on Main Street and I drive down a little bit and I stop at the Walgreens. And I tried talking to Uriah then, and I was like, look, if it was self-defense, go ahead and turn yourself in. Because he had already told me that it was self-defense. I was like, what was self-defense? At that time, he tells me that he can't because of the position of the body.
And what did that mean to you?
That he actually somebody.
At that point, did you know who had been murdered?
No, I did not.
Once you're talking to him at Walgreens, does he say anything else at Walgreens?
No, when we were sitting at Walgreens, he was very nervous, fidgety, looking behind his shoulder. I think he thought I was setting him up because he kept looking out the back window. Once we got on the highway and started off towards, I believe, Alvin, he handed me $500 and then we stopped in Alvin.
So at this point, what is Tara doing?
Tara's in the back seat. Her and Uriah are whispering the whole time. She doesn't really ever conversate with me.
So is Uriah who you predominantly speak to throughout this drive?
Yes, ma'am.
But Tara and Uriah are communicating.
Yes, ma'am.
What happens next?
So after we go to Alvin, I guess Tara had told Uriah that she was wanting some snacks and stuff. So I stop out at a convenience store. Uriah hands me $20, goes and says, go in and get stuff for us, get whatever you want. But he tells me stuff that she wants and stuff for him. So I go in, I get it, I come back out, I give it to them. In the parking lot of the convenience store, we both roll a bowl. I have my own stuff.
I'm going to pause for a second. For those of us who may not be as drug savvy, what do you mean by roll a bowl?
So when I say roll a bowl, we have a glass pipe that has methamphetamine in it, and you literally roll it back and forth for it to smoke.
Okay. And you said you have your own stuff?
I have my own stuff. Uriah has his own stuff. I don't know if this is stuff that I had given him 2 or 3 days before or not.
Okay. So you just knew that you each had your own substances to use?
Yes.
Okay. So do just you and Uriah smoke at that point, or what does Tara do?
No, ma'am. She's also in the back seat, and Uriah helps her light the bowl and roll it because me using drugs for over 15 years, I kind of know the signs of when somebody's new, and I could tell that she had just recently started smoking.
Later in 2025, Uriah Urick's trial began in Galveston County. Prosecutors presented digital evidence, including messages and online posts, along with testimony from investigators and witnesses. After hearing all the evidence, the jury found Uriah Urick guilty of capital murder. On November 10, 2025, he was sentenced to life in prison without the possibility of parole. As of the most recent updates, Tara King's case remains pending, with her trial scheduled for 2026. Prosecutors have stated that testimony from cooperating witnesses, including Hodge, will play a key role as the case continues. In January 2024, a boy named J.D. Williams was staying in a dorm room at Georgia Southwestern State University in Americus, Georgia. He was in the care of Trinity Poague, an 18-year-old college student and former pageant title holder who was dating the boy's father. Late one night, J.D. was found unresponsive inside the dorm. Campus police were called, and emergency responders rushed him to a nearby hospital. Despite medical efforts, he did not survive. Because of the seriousness of the situation, the Georgia Bureau of Investigation was brought in to assist. Medical professionals later determined that J.D.'s injuries were severe and not consistent with a simple accident. Investigators focused on the period of time when Poague was alone with him, which became central to the case. During the trial, the jury heard testimony from Megan Pietz, a college student who lived across the hall from Poague at the time.
Did you meet Trinity Poague at any time?
Could you repeat the name?
Trinity Poague. I want to call her Tiffany also. Trinity Poague, I'm sorry.
Yes, sir.
And does she live in the same dorm as where you were living in that January of 2014?
Yes, sir.
Her room compared to yours, how close was it?
Across the hall diagonally.
And so, not too far away?
Yes, sir.
You got to say yes or no for court reporter. Back on January the 13th, getting later into the day and night, bleeding over into January 14th, which would be the early morning hours, which you might commonly still think of the same Saturday night, but getting into Sunday morning. Did you hear anything that got your attention during the night while you were in your dorm? Well, first of all, were you in your dormitory during that time period?
Yes, sir.
And when you were in your dormitory during that time period, how late did you stay up that night on Saturday, January 13th? Do you recall?
I don't recall, but I remember being asleep and being woken up.
Okay, when you were sleeping, got awakened, what awakened you?
A baby crying.
Okay, was it, can you describe, I know a baby crying is a baby crying, I guess, but is there any way you can describe as far as volume or anything of that nature?
It was particularly loud considering I was across the hall.
Okay. Enough that it awakened you?
Yes, sir.
Now, after you heard the baby cry, was it just one cry, or was it baby crying, or what was going on?
It was continuous and then eventually stopped.
Okay. Do you know how long you heard the crying before it ceased?
I don't remember.
And was this in the middle of the night?
Yes, sir.
Yep, that's all the questions I have, John.
All right, cross-examination.
Good afternoon, Ms. Pietz. The baby was crying that night, loud enough at some point to wake you up, right around 1 o'clock in the morning.
Yes, sir.
Is that about right? And you don't know how long he cried thereafter, but just until, I guess you said, until he stopped crying.
Yes,
right?
sir.
That wasn't the first time that baby had woke you up crying, was it?
No, sir.
Actually, he cried a lot when he was there around Miss Poague, didn't he?
Yes, sir, every time.
Every time?
Yes, sir.
He actually behaved better and was calmer if, like, her roommate or somebody else was there that could help, tend to him instead of her having to do it, didn't he?
Yes, sir.
But he responded better to other people than he did to her.
Yes, sir.
She told you at some point, or did she tell you that she had known that child for his whole life?
I don't recall.
You don't recall that? Do you remember interviewing with the GBI?
Yes, sir.
Agent over at I think y'all interviewed over in the police station on campus?
Yes, sir.
Interviewed with Special Agent Joe Chestnut?
Yes, sir.
Does that sound right? And I mean, there's an audio recording of it, not a video. There's an audio recording of it, but there's also a summary that the agent prepared, which is, his note summary of the interview. Okay.
Yes, sir.
If I let you take a look at that for just a moment, do you think that might refresh your memory about whether or not she had told you anything about how long she had known the child?
Yes, sir.
Okay.
Your Honor, I object to using refreshment of the agent's notes to try to refresh her memory.
Well, it doesn't matter whose notes they are. I mean, anything that if the witness says that she believes it will refresh her memory, then
I think
it's
she can
permissible.
review the notes and then make if it will refresh her memory.
If it doesn't, it doesn't. Start maybe like right in here and read down 2 or 3 paragraphs. Just read to yourself, not out loud. you have a chance to read over that?
Yes, sir.
And in fact, having done so, does that refresh your memory at all about whether or not she had led you to believe, or led everyone to believe certain information about how long she'd known the child, things like that?
I remember her having conversations about describing knowing the child and helping take care of him, but I don't recall that particular conversation.
Okay, you don't recall a particular conversation where she said she'd known him his whole life.
Correct.
But you do recall conversations where she had talked about the child, taking care of him, and that sort of thing.
Yes, sir.
Where she had seen him and taken care of him away from where y'all were, away from the dormitory.
I don't remember.
You don't remember that? Okay. All right. Did you ever hear her express any opinions of her own about the child?
Yes, sir.
What kind of opinions did she express about J.D. Angeles?
They were never directly to me, but they were in group settings, and she would describe it.
Objective is not said directly to her. Now, are you saying it's heard through a group but not from her?
I want you to clarify as to whether or not she heard it,
Yes,
not,
sir, I
not that she
certainly
heard
will.
it secondhand. Okay. And I do need you to speak into that microphone a little louder, okay?
Yes,
All right.
sir.
Thank you.
When I ask you if you had heard her express any opinions about the child, you said in a group setting, was it a setting where you actually heard what she said?
Yes, sir. It was in her room.
Okay, not her talking to someone else and them telling you she said something. It's something you actually heard. She just wasn't talking to you individually.
Yes, sir. It was a group of people in her room.
Gotcha. Okay. So what opinions did you hear her express about the child?
She was describing that she didn't particularly like him.
It sort of seemed obvious from her interactions with the child that his feelings about that were mutual.
Yes, sir.
Wouldn't it? Nothing further.
Redirect?
No, Your Honor.
Pietz testified that on the night in question, she was awakened around 1 a.m. by loud, continuous crying coming from Poague's dorm room. She said the crying was strong enough to wake her despite the distance between the rooms. Pietz also told the court that this was not unusual, explaining that J.D. often cried when he was with Poague. She stated that, based on what she personally observed, the boy seemed calmer and more responsive when other people were caring for him, compared to when he was alone with Poague. Pietz also testified that she had heard Poague express in group settings that she did not particularly like caring for the boy. Within days of the incident, Trinity Poague was arrested and charged in connection with JD's death. Prosecutors later filed a 6-count indictment that included malice murder, 2 counts of felony murder, 2 counts of aggravated battery, and 1 count of cruelty to a minor. The case went to trial in December 2025 in Sumter County Superior Court. Prosecutors argued that the evidence showed J.D. suffered fatal injuries while in Poague's care. The defense challenged those claims and argued the state failed to prove intent. After nearly 3 hours of deliberation, the jury returned a mixed verdict. Poague was found not guilty of malice murder, meaning the jury did not find proof of a planned or intentional killing. However, she was found guilty of 2 counts of felony murder, 2 counts of aggravated battery, and 1 count of cruelty to a minor. The court then moved directly into sentencing.
I'll hear from the state concerning sentencing as to count 2 and count 6. And of course, if you want to present any witnesses, you certainly can. And I believe the sentence possibilities are life on count 2 or life without parole. And on cruelty to children in the first degree, the sentencing range is 1 to
5 to 20.
5 to 20. Okay. All right. I'll hear from the state first.
Your Honor, the state proposes that the appropriate sentence in this case would be a sentence of life in prison on count 2 with a sentence of 20 years consecutive on count 6. I understand that Ms. Poague is very young. I think this is the terrible tragedy of these kinds of cases. I have as a victim and who was at the time a teenager as the defendant, and I think that the jury's verdict. It's not always very possible to get an interpretation of what the jury might have been thinking, but I think if you look at the way the verdict is structured, that it suggests to me, at least, that by finding a not guilty on malice murder, that there was a belief that there was not evidence of a specific, essentially a specific intent to kill or a deliberate intention to kill. And that would be the distinction between count 1 and the remaining counts. And so, in my view, if I accept that as a finding of fact, from my perspective in proposing a sentence, if I consider that or accept that as a finding of fact of sorts, that there's evidence of malice, that there's evidence of, disregard, conscious disregard for the consequences of her actions, then I feel justified in asking for consecutive time. But if I do not believe that the evidence supported this jury in making a finding of a deliberate intention to kill, such as would support a malice murder conviction, then I'd feel constrained to leave the recommendation at life without parole. At life in prison as opposed to life without parole.
All right. Do you wish to present anything? Anybody wish to say anything from the family, or are you presenting any testimony?
No, sir. We're not presenting any testimony, and I'm not. The father of the child is not father and aunt are here, of course, but I'm not asking them to make statements to the court, and I've told them both that they could if they wanted to do so, but we're not going to.
Okay. Mr. Gamble?
We recognize felony murder. I don't think if they're recommending life with parole, that's as lenient as a sentence could be under that particular charge. I don't think you can go below life in prison for a felony murder charge.
Right.
So we don't dispute that. We would ask, though, Your Honor, the cruelty. They're asking for consecutive 20 years. If you put that on there, you're coming very close to being life without parole, in that she will not come up for parole currently for 30 years and then add 20 more to it. Would be very close to her entire lifetime. And we would ask the court to consider, you've heard the evidence and you know generally what the whole circumstances were. She was 18 years old at the time, a young girl that had not had any trouble with the law, any problems, and was doing well. Now, obviously, she's accused of a horrendous crime that we fought about in court, but we accept the jury has made a verdict, whether I agree with it or not. So she has to now face what the consequences are of that. But it should not be so severe that it would be akin to life without parole. And that would be what happens if you make this consecutive serving time sentence. So we would ask that on the cruelty to children, that it run concurrent with the life sentence that she is going to be imposed on her for the felony murder. So felony murder plus 20 years, but run concurrent with the felony murder charge. Yeah.
All right, Ms. Poague, if you'll stand up, please. I don't do a lot of speaking when I'm passing the sentence. I've heard the case, and I've considered the tragedy on the left side, on my left side, and on the right side, and there's a lot of tragedy to go around here. The whole time that I'm hearing a case, I think about what the appropriate sentence would be. And this conduct all led, in my opinion, to the offense of felony murder. Even the charge that would have merged with count 3, but does not because count 3 is vacated by count 2. That's a lot of technical jargon. But the bottom line is you're going to receive a sentence of life in prison, which is the appropriate sentence for the conduct that you have been convicted of. And that is going to essentially be the sentence that the court passes in this case. You will be sent on, so on count 2, I sentenced the defendant to serve life in prison. And on count 6, I sentenced the defendant to serve 20 years in the state penitentiary. Those sentences will run concurrent. I do wish to advise you, Ms. Poague, that you have 30 days to appeal. You also have 4 years within which you could seek habeas corpus. I hope this can bring some closure to the family. It's just a complete tragedy. And I hope that you can, in your older days, have some sort of life after serving this sentence. And life while you're in prison. I guess you just have to make the best of it. But that's the sentence of the court. I wish everybody the best.
After reviewing legal arguments about which charges could be punished separately, the judge imposed a sentence of life in prison for felony murder with eligibility for parole after 30 years. A 20-year sentence for cruelty to a was also imposed to be served concurrently. Before closing the hearing, the judge described the case as a tragedy and informed Poague of her right to appeal. With sentencing complete, the trial came to an end and Poague was transferred into the custody of the Georgia Department of Corrections. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.